Well, he's back. And you know, when I say that, there's one of only two people, right? Today it's Karl Ulrich from Sebaly, Shillito Dyer, a best old friend. And again, if for those of you newer viewers who have not seen a lot of the shows, Karl and I started this back in 2017.
It has been a while, hasn't it?
Yeah. I don't know. I just can't believe that it's that much time that's passed.
I know. It's hard to get around. Yeah.
I'm not going to talk about how much we've changed.
No, well, you haven't changed at all, Pandy. I have a lot less hair than I did back in 2017. So,
and I have a lot more of something else. So.
We won't go there.
No. But you're the guy I thought of with this topic. We've got to set everybody straight.
It's interesting what we're seeing now. I think this is some very important policy changes are coming out of Washington, and I think they're going to be important for employers in particular to understand, but also for employees as well. This is it's a landscape change in many ways to what was once known as affirmative action, but also anti-discrimination rules and how you prove an a discrimination case. These things have evolved a bit in the last probably year or two, more than they have in several decades. So I think it's important to talk about some of those things. And one of the topics you and I had discussed earlier was this most recent case that just came out a couple days ago from the United States Supreme Court called Ames versus Ohio Department of Youth Services. And it talks about Title VII and how to prove a reverse discrimination case and changes some of the rules on how that's done, at least here in the Sixth Circuit Court of Appeals. So we can talk a little bit about that. But it's, I think, an important case to note and to consider how that might, how employers might be thinking about discrimination cases going forward. Well,
and you mentioned the Sixth Circuit. Yes, but again, I want everyone to take notes because this is going to spread.
Mm-hmm.
This is going to open up the doors for what we feared would be coming down the road if ever an administration change or a different mindset came in.
Right. I think we should. What would be helpful, I think, is maybe we go back to the starting point, and that's what Title VII is all about. Title VII is 60s era law. It basically says can't discriminate in employment on the basis of several categories, right? Race, sex, which includes gender identity and sexual orientation, religion, color, and which one am I forgetting? National origin. That's the other one. So there are those categories in Title VII, which are prohibited categories. You can't make an employment decision based on one or more of those protected categories. That's what Title VII was all about. And in 1973, the United States Supreme Court decided they're going to come out with a decision called McDonnell Douglas versus Green. And in that case, they set up a kind of analytical framework. This was a process whereby claims would be evaluated by the courts. And it's important to know this process because it helps you kind of understand the decision paradigm that courts go through, and to some extent how you manage your own internal decision-making in the HR field. So what McDonnell Douglas said was it's really a three-step process to prove a discrimination claim. That you have to first, the claimant, the person who is discriminated against, has to make a preliminary showing that they were protected by the law, that they were treated differently than someone similarly situated but outside the protected group or whatever the group happens to be, and that they suffered an adverse employment action. In essence, that's what a preliminary showing requires. And it's a flexible test under McDonnell Douglas, or at least it was. And then what the employer can do is, as an affirmative defense, the employer comes back under the McDonnell Douglas paradigm and says, well, employer then has the burden of showing that the decision they made was a legitimate, non-discriminatory basis. It was based on something unrelated to a protected status. The burden then shifts back to the claimant under the McDonnell Douglas standard for the claimant to prove that that legitimate business purpose proffered by the employer is actually a pretext, that it really was a fake designed to hide and employment discrimination, discriminatory intent. That's the three-step process. So claimant has the burden, employer comes back with a defense, and then claimant comes back to show that that defense was a pretext, and that's that three-step process. Now, what happened in the case law is that in certain courts of appeal, in the federal court system, they handled the so-called cases of reverse discrimination a little differently. So there might be a person who wasn't in a typically protected class, would be a white male, for example, might be claiming reverse discrimination, that they didn't get a position they were suited for because the employer favored someone who was perhaps African American or lesbian female or whatever. That so-called reverse discrimination idea became more and more common as the courts were grappling with how to kind of weigh discrimination in employment generally. And so what a couple of circuits, actually 5 of the 12 circuits, courts of appeal came back with is they created a heightened standard of proof. They said to prove reverse discrimination when you're not in a traditional minority group, to prove reverse discrimination, you need to come up with additional surrounding circumstances to meet that first step that we talked about.
Oh, that was just something they came up with?
That's right. That's right. They said, Title VII was really designed to protect certain groups of individuals, and that because you're not in that particular group, in order to prove discrimination, actionable discrimination, if you're not in that group, you have a higher standard.
So you have to try harder.
Essentially, that's right. And what that meant in a lot of these cases was that if you were alleging a reverse discrimination claim against an employer, you had to come up with evidence of surrounding circumstances, pattern and practice, things that you wouldn't necessarily have to prove if you were a member of a minority making that claim.
Oh, so that's discrimination in itself.
Well, it's a different standard, but not every circuit court of appeal did that. It was the 6th, our circuit, was the 7th, it was the 8th, the 10th, and the D.C. circuit. Those, I think, were the 5 circuits who adopted this rule. All the other circuits, and that's mostly the Middle West, Plains states, all the other circuits, East Coast, West Coast, and Deep South, applied the same standard for all discrimination claims. And so you had this split disagreement between the circuits.
Wow.
And that lasted for decades until June 5th, 2025. And in a remarkably, well, let me put it this way, in our world, a unanimous decision by the United States Supreme Court is a pretty unusual thing these days.
Extremely.
And so Justice Jackson, Biden appointee, wrote the decision of the court. It was a unanimous decision. There was a concurring opinion. I'll come back to that later because that's kind of an interesting thing for future reference, something I think we need to take note of. But the result of the case was agreed to by all 9 justices, and essentially what they said was, no. This rule that was adopted by these 5 circuits where you have to show additional proof of discrimination if you are a claimant not in a traditional minority group, alleging reverse discrimination, they said the same standard would apply to you as it does to everybody else. It's about an individual being treated the same regardless of whatever racial category they happen to be in or whatever religious category they happen to be in or whatever, gender or, sexual orientation they happen to have. So this case actually was a sex case. It was a sexual orientation case, the Ames case was. The claimant was a straight white female who alleged that she was not promoted and later demoted in favor of some LGBTQ employees who she claimed were less qualified. And the court said, the original court said, you didn't prove that, those extra circumstances. Took it up to the Supreme Court. Supreme Court said, no, she didn't have to do that. We're we're now applying the same standard. We're clarifying what the rules should be under McDonnell Douglas for all cases involving discrimination, whether they're reverse discrimination or discrimination based on minority status. And that rule is now the law of the land. And what that does, in effect, is it makes it easier in many ways for claimants who are not members of a traditional minority group to allege a discrimination claim if they can prove that their race was a factor, or their gender, or in this case, a sexual orientation was a factor, or was involved in the decision-making process. And that can, in some ways, complicate things for employers. But from a legal perspective, for us lawyers who apply these rules, it makes some sense to have the same rule for all circuits, right? Because you had a different standard in California than you did here in Ohio, which made no sense at all from a practical standpoint. Yeah. So now, according to the Supreme Court, that rule is across the board.
Did it really have to take the elimination of DEI to get to this point? Don't you think that was the catalyst?
That's a really interesting question. Theoretically, no. But I think there was some momentum in that direction as a result of the shift in focus away from DEI and away from affirmative action in the traditional sense. This isn't an affirmative action case so much as it is a pure disparate treatment case.
Yeah.
But having said that, I think, you can sometimes read the tea leaves. And your question's a good one. I think the two are related in some ways. I think that the Supreme Court is really thinking differently now about discrimination in the workplace than it has traditionally for decades. Mm-hmm. I don't think the laws are going away. They're certainly not going to go away. They're just interpreting them differently. And in this case, in my opinion at least, having a consistent standard across the United States makes the most sense.
Well, let's now help the audience apply this to themselves, because I think the floodgates are going to open. Mm-hmm. I think this is going to encourage others now to say, well, then I was reversed, I was discriminated against. And so when I'm working with a client, I'm always reminding them, okay, do you have clear understanding of what the company needed, what were the business needs, and how this individual met those needs?
Mm-hmm. Well, it's a great point. So decisions are made, hopefully, on non-discriminatory business reasons, right? If you're trying to fill a position, you're doing it with the most qualified candidate, and employers have always wanted to do that in principle.
Yeah.
But what's going to happen now, I think, is it's going to be even more important for employers to be very clear about what the job requirements are, be very clear about how they evaluate and assess applicants against each other, and to be very careful, even more careful than they have in the past. I mean, you'd never inject race or sexual orientation into a decision like that, obviously, but because the landscape makes it easier for claims on reverse discrimination to come up, it makes it all that more important now that merits-based decisions are properly documented, are properly thought through, because aggrieved employees, even those in the majority, will have the potential for raising the same concerns. And as a practitioner in the law, one who practices primarily in the Sixth Circuit and has in the past, as I'm evaluating whether to take cases of reverse discrimination, and I haven't taken many in the past, because of, among other things, that heightened standard that had traditionally been the case. For a lot of practitioners, it makes it possible, I think, to see a way forward for their clients where they didn't before. Mm-hmm. Evening the playing field, I think, is a laudable goal. But I think you're right about the possibility of increased litigation as a result of that.
Yeah, ladies and gentlemen, I want you to go back to your offices and think about a couple things. I want you to go back and think about some recent promotions, recent transfers, even terminations, people who maybe resigned that you were involved somehow in a pay increase or something where it didn't go quite the way they thought it should go. And just do a self-audit. We've talked about the importance of self-audits. Go back through that paperwork. Look at the performance evaluations. Look to see how those decisions were made not to choose that person or not to provide that increase, and why you chose someone else. Sometimes, again, if you just prep yourself, we can learn from our past experiences, just as we are with this. McDonnell was 52 years ago.
That's right. Yeah.
So
half century, right?
Yeah. I mean, you and I weren't practicing back then.
No,
But
gosh, no.
we're,
I wasn't even born yet.
oh, I was.
Yeah, I was too, actually.
Oh, gosh. But you're getting my point. You understand where Karl and I are trying to get you to go on this. This is going to affect you. Maybe not tomorrow, maybe not next month, but this particular change is something you need to be aware of and stay on. Karl, how can they get a hold of you?
I am an attorney in Dayton, Ohio. I'm on the web at www.ssdlaw.com.
And he'd love to hear from you, just as we would. If you have any other questions or anything, you know how to reach out to us, please, because that's what we're here for. Thank you for watching and listening to The Human Resource.